You went on to abuse the corpses of these 3 victims. You stripped them from the waist down. You folded them in half. You wrapped them in multiple layers of trash bags, and you discarded them.
We're here today because 2 teenagers when the vehicle they were in was struck by a 7,000-pound pickup truck.
My baby.
On Father's Day in June 2023, tragedy struck on State Route 78 in Vista, California.
The defendant was driving with a blood alcohol level of 0.14 while having her 6 children unsecured, unseatbelted in the car. Driving under the influence is in and of itself a public safety concern.
33-year-old Sandra Ortiz pulled her SUV over after luggage fell from the roof. Her daughter, Amy, and son, Alan, exited the vehicle to retrieve the bags and were fatally struck by an oncoming car.
Based on the investigation, it appears that the defendant remained seated in the vehicle and does not appear that the defendant made any efforts to stop the children from exiting the vehicle or to get the children out of the freeway.
Investigators determined Ortiz remained in the driver's seat and made no effort to stop them. Officers noted signs of intoxication, and her blood alcohol level tested at 0.14, nearly twice the legal limit.
When law enforcement arrived, they detected an odor of alcohol, red, watery eyes, slurred speech, and an unsteady gait.
Ortiz was arrested and charged with multiple offenses, including 2 misdemeanor DUIs and 6 counts of child endangerment tied to her son and daughter's.
My baby. A good mom.
It's nothing but love for our kids.
During her court appearance, she broke down in tears while the victim's father publicly defended her character.
I am going to have Ms. Ortiz released from custody. I am going to place Ms. Ortiz on supervised own recognizance release condition.
Despite concerns from the prosecution about the family's recent move and lack of stable housing, the judge released her under supervised conditions. Ultimately, Ortiz was sentenced to 3 years and 4 months in prison. In November 2017, Logan Mott killed his grandmother, Christina French, in Neptune Beach, Florida. After fatally and her, he fled in her car, only to be apprehended near the Canadian border. French's body was discovered in her backyard, and Logan was charged with her murder. His father, Eric Mott, a Jacksonville Sheriff's Office lieutenant, testified during the trial, revealing the troubled dynamics within the family, including allegations of domestic violence and neglect between Logan and his mother. Despite this, Eric emphasized Logan's positive and close relationship with his grandmother, who had always been a caring figure in his life.
She enjoyed being the grandparent and always kind of being the good person and, just spoiling Logan, and, she just liked being a grandma. And Logan, their relationship was great.
Psychologists suggested that Logan's struggles with type 1 diabetes, bullying, and emotional trauma may have played a role in his actions. At the conclusion of the trial, Logan pleaded guilty and was sentenced to a minimum of 15 years in prison, with the possibility of parole. He will serve his sentence in a juvenile facility until he turns 21, after which he will face a 10-year probation period. Jesse Alvarez was convicted for the murder of Mario Fierro, which occurred on February 1st, 2021, stemming from a deep-seated jealousy after Alvarez's ex-girlfriend, Amy Gembara, became engaged to Fierro. Alvarez, who had been stalking Gembara, plotted the murder after she broke up with him and sought a restraining order. On the day of the murder, he ambushed Fierro outside his home and shot him, ultimately him in a brutal, premeditated attack. During the sentencing phase, Gembara gave a heartfelt statement, describing how the murder shattered her world, but also expressing her desire to move forward as a survivor.
One moment, Mario and I were planning our wedding. Then the next moment, our loved ones were planning his funeral. None of our loved ones expected this to happen, nor do we want to be at this sentencing today. Mario's confidence and faith were contagious, and he could light up a room with his energetic spirit. That's what I loved about him. I felt secure in Mario's love for me and had the gift of knowing his love every day.
Despite Alvarez's defense team arguing that his autism spectrum disorder should warrant a new trial or a lesser sentence. However, the judge found the crime to be exceptionally cold and heartless. Alvarez was sentenced to life in prison without the possibility of parole, plus an additional 25 years to life. The judge noted the severity of the crime, emphasizing that, had the murder occurred earlier, Alvarez could have faced the death penalty. Julie Ann Stewart and her husband Gerard lived in Jacksonville, Florida, where they raised their son. After nearly 20 years of marriage, Julie filed for divorce in April 2018, seeking custody of their son and the family home. Friends and neighbors knew her as a kind and generous woman.
She would take me places like Adventure Landing and stuff.
Gerard, a Navy veteran working at a car dealership, was reportedly struggling with the emotional weight of the separation. Just days before the tragedy, Julie had updated her divorce filings, signaling that the process was moving forward. On June 15, 2018, Gerard confessed to a neighbor that he had his wife. Concerned, the neighbor contacted authorities, leading to a large police response. Gerard briefly left the house in his vehicle, then returned and refused to come out, resulting in a standoff. The standoff lasted for hours on Cavalry Boulevard, leaving neighbors shocked as the couple had been seen as a quiet and seemingly happy family.
I've never heard the parents argue or fight. They seem like a really healthy family.
Julie's son's friend was shocked as well.
I was gonna play with him at 3, and that's when it happened. I wanted to talk to him and see if he's okay and if he's gonna go to my school next year.
Gerard was eventually taken into custody and received medical care. Julie was later found in the family vehicle. The case moved to trial in 2022, where Gerard was found guilty of tampering with evidence and later pleaded guilty to a lesser charge related to Julie's. He was sentenced to 40 years in prison. Their son, who was not home at the time, was placed in the care of family members. In 1994, the remains of a boy were found in Lake City, Florida, but his identity remained a mystery for years. The case stayed cold until 2014, when the National Center for Missing and Exploited Children helped raise awareness, prompting Fred Laster's twin sister to suspect that the remains could be her brother's. DNA testing confirmed the identity in 2016, revealing that Fred Laster, who had been missing since 1995, was the victim. Investigators linked the case to Ronnie Hyde, a former youth pastor and family acquaintance. DNA evidence connected him to the crime scene, leading to his arrest in March 2017. As the investigation unfolded, disturbing new details emerged, with Hyde allegedly involved in the abuse of other boys during the 1980s and 1990s. Authorities found digital material linked to these crimes, which included recordings of some of the abusive acts. In 2022, Hyde was found guilty of first-degree murder in the death of Fred Laster and was sentenced to life in prison. In July 2023, Aria Page tragically died after being left for nearly 5 hours in a hot SUV outside her caretaker's home in Baker County, Florida. Rhonda Jewell, 47, had picked up Aria that morning, but forgot the girl was still in the back seat when she went inside. The temperature inside the vehicle soared past 130 degrees. Aria was discovered unresponsive when her mother, Brooke Page, arrived during her lunch break. Despite rescue efforts, the girl was pronounced dead at the scene, with her internal temperature exceeding 100 degrees Fahrenheit.
Ask the clerk to please publish the verdict.
In the Circuit Court of the 8th Judicial Circuit, in and for Baker County, Florida, State of Florida versus Rhonda Jewell, case number 02-2023 CF333. We, the jury, find as follows: as to count 1 of the information, the defendant is not guilty. We, the jury, find as follows as to count 2 of the information. The defendant is guilty of third-degree felony murder as charged in the information. We, the jury, find as follows as to count 3 of the information. The defendant is guilty of leaving a child unattended or unsupervised in a motor vehicle causing great bodily injury as charged in the information. So say we, this 8th day of November 2024 at McClinney, Baker County, Florida. Signed by the foreperson, David Saints.
Very good. Be seated, please. Is either counsel aware of any further proceedings that would require the presence of the jury?
Following a trial in November 2024, a jury found Jewell guilty of third-degree felony murder and leaving it unattended in a vehicle, causing great bodily injury. She was sentenced to 17 years in prison. However, in early 2025, Jewell was granted a $100,000 supersedeas bond pending appeal, allowing her to be released under conditions including GPS monitoring, a nightly curfew, and a ban on unsupervised contact with girls and boys. The decision to release her sparked public backlash, with Aria's family demanding that the bond be revoked in the interest of justice. Terise Powe, better known by his stage name Shorty, is a Jacksonville rapper whose life has been marked by a series of violent events linked to gang activities. In March 2020, Powe was injured in a that tragically claimed the life of his girlfriend, Anandi White, a beloved cheerleader at Rebo High School. The attack, which was part of a gang retaliation, was aimed at Powe, with White inadvertently becoming a victim. The tragedy led to an investigation, and in January 2021, Roland Ball Jr. and Xavier Porter were arrested, facing charges of second-degree murder and aggravated battery in connection with White's. The following year, in September 2021, Powe was involved in another shooting that resulted in the death of rapper Xavier Mays, also known as 187 No Face. Alongside his associate, Jacob Sykes, Powe is accused of firing on a vehicle that carried Mays and two others, including rapper Noah Williams. Both Powe and Sykes were arrested and now face multiple charges, including second-degree murder, attempted murder, and firearm possession by a convicted felon. In the upcoming trial, Powe's legal team has subpoenaed Williams to testify, shedding light on the complex and often deadly rivalries within Jacksonville's rap scene. In August 2021, Michael Motley, 61, caused a fatal crash while driving under the influence of alcohol at around 3 a.m. in Jacksonville, Florida. Motley ran a red light at the intersection of U.S. Highway 1 and Grand Bay Parkway, colliding with 22-year-old Megan Mooney's car. She had been a student at the University of North Florida, just months away from graduating. Motley's blood alcohol level was found to be more than twice the legal limit, and his reckless speed contributed to the fatal incident. Tragically, Megan died from the crash, leaving behind a grieving family and friends who deeply mourned her loss. Following a thorough investigation, Motley was arrested in August 2022 and faced charges including DUI manslaughter and vehicular homicide. Megan's parents, John and Carrie Mooney, expressed the immense pain caused by her, emphasizing the needless nature of the tragedy.
I have dreaded having to look at this person, Michael Motley, in the face, because I spent, admittedly, 2 years despising him. Did she suffer waiting for an ambulance to reach her? What thoughts were running inside her head?
There's literally no excuse for someone getting behind the wheel.
Megan's brothers also addressed Motley directly.
My family will never be the same again, and there will forever be a void that can never be filled because of one man's actions. I will be praying for you.
Megan's friends also came and urged the public to take responsibility when it comes to drinking and driving, hoping to prevent other families from suffering a similar loss.
Megan was following every law, and she's the only person from that car crash who is in here with us today. We as a society are better than this. Uber, Lyft, countless companies are dedicated to keeping reckless drivers off the road.
In July 2023, he was sentenced to 12 years in prison, along with the permanent revocation of his driver's license and mandatory DUI education courses. In May 2023, tragedy struck on Long Island when 34-year-old Amandeep Singh drove his pickup truck the wrong way down North Broadway in Jericho, hitting a car that was carrying 4 boys. The crash, which occurred at speeds of around 95 miles per hour, 2 boys, Drew Hassenbein and Ethan Falkowitz, instantly. The other 2 boys were seriously injured but survived. Singh, who had a blood alcohol content of 0.18, more than twice the legal limit, and in his system, fled the scene on foot. He was later found hiding behind a dumpster at a nearby shopping center.
It's just very tough to just see this, and as I said, I really hope that the defendant doesn't make the families go through a trial on this, because every day that they come here is excruciating.
We're here today because 2 teenagers and 2 other teenagers were injured when the vehicle they were in was struck by a 7,000-pound pickup truck being driven the wrong way at 95 miles an hour. That vehicle, we allege, was driven by this defendant.
This family, this entire family, extends its condolences to these families. Everybody is hurting here. Everybody's in tremendous pain.
Singh was charged with multiple offenses, including manslaughter, vehicular homicide, assault, driving while intoxicated, DWI, and leaving the scene of an accident. In January 2025, he pleaded guilty to 15 charges related to the crash. During his sentencing in February 2025, Singh was handed a prison sentence of 8 1/3 to 25 years. In April 2022, 23-year-old Gavin Conroy was involved in a tragic crash in Orange Park, Florida. While stopped at a red light on Wells Road, Conroy's vehicle was struck by a truck driven by Clifford Ringer. The impact caused a that severely injured Conroy, leading to extensive surgeries. Despite these efforts, Conroy succumbed to his injuries on August 10, 2022. Ringer, who had a long history of traffic violations and a suspended license, initially faced charges of careless driving and driving with a suspended license. Following Conroy's death, these charges were upgraded to vehicular homicide. Ringer, who had been repeatedly cited for reckless driving, was released on bond, but had it revoked in July 2022 after a red light violation.
We refused to have anything in Christmas wrapping paper, had to be birthday wrapping paper, but everyone brought a gift, and it was in honor of something that we would have given to Gavin. So we all got to go home with something special.
Throughout this painful process, Conroy's family showed resilience, continuously seeking justice and working to raise awareness about the consequences of reckless driving.
Every court date, obviously, it takes a lot out of us. You know, the emotions are really high. So it's hard coming every time to court, but we want them to do the investigation the right way.
However, before he could stand trial, Ringer passed away on January 27, 2023, at the age of 49. Authorities found him unresponsive in a friend's home, though no foul play was suspected. Despite Ringer's passing, the family's determination to honor Gavin's memory remained unwavering. On May 18, 2017, a deadly fire broke out at the Spartan Box Gym in the Ingram Square Shopping Center, San Antonio. Firefighters Scott Deem, Brad Phipps, and Robert Vasquez entered the burning building during a rescue operation. A mayday call soon followed. Phipps and Vasquez were injured, but Deem was tragically trapped and later found dead inside. Investigations revealed that Emond Johnson, the gym's owner, had intentionally set the fire. Struggling with financial issues and facing eviction, Johnson confessed to starting the blaze in an attempt to escape his lease. Surveillance footage and inconsistencies in his statements confirmed his involvement. Years later, in July 2023, Johnson pleaded no contest to charges of murder and arson, resulting in. During the sentencing hearing, Scott Deem's daughter delivered an emotional victim impact statement describing the pain of losing her father and the milestones he would never witness in her life.
You may know him as a firefighter, but I know him as so much more. My dad was a prankster, the light even in the darkest places. My best friend, and the person who protected me and held the light up for me when things became rough. May 18th, 2017 was the day you took him from me. I was thinking he was going to come home that morning with a big smile on his face, like he normally did. But he didn't because of you. Looking at you today, I continuously ask myself why, which is a question I've been asking myself for what feels like decades. Losing him was so much more than grief. The moment I found out, it felt like the world slipped out of my hands and suddenly I was brought into a new one. When you look at us today and see the hurt and tears in our eyes, I hope you take this time to not only reflect on your actions, but to see the person you took from us. Till this day, I still ask myself what life would be like if my dad were still here, which is a question that can no longer be answered. You took something from me, not only me, but the people around you. And now I not only have to deal with the fact that my dad will no longer be around to see me graduate college, become a mother, walk me down the aisle, and see me grow into the person I've always wanted to become, but to also deal with the fact that you're still alive and have a family to come home to, but continue to sit here and act as if you lost everything. Life is unexpected, and that is something I've learned after he passed, to treasure every moment, every day as if it was your last.
His widow, Jennifer Deem, also wrote a heartfelt letter to the court.
Jennifer Deem is the widow of Scott Deem. She sent a letter and she's requested that I personally read it to the defendant. I've tried not to think about this day, but I knew it would eventually come. I thought I'd be able to tell you myself what you've done and how you've affected our lives, but the longer I go without Scott, the harder it gets.
Johnson was sentenced to 30 years in prison, eligible for parole after serving half the term. Following Deem's federal and state investigations highlighted flaws in the firefighting response, leading to reforms in safety procedures within the San Antonio Fire Department. On October 31st, 2017, Chad Absher fatally shot his ex-girlfriend, Christina Ashley Rucker, and seriously wounded her sister, Lisa Rucker, inside their Jacksonville, Florida home. The violence stemmed from an argument over car keys, which escalated when Absher physically attacked Ashley. After Lisa's boyfriend left the apartment during the dispute, Absher shot both sisters, Ashley, and injuring Lisa in front of their sons. Absher fled the scene but was later captured and charged with first-degree murder, attempted murder, and illegal firearm possession. At trial, Absher claimed self-defense, but the jury found him guilty on all counts.
In a variety of different facts and circumstances. But I look at each case and each person individually. And the facts and circumstances of this case were by all accounts horrifying. The fact that this happened in front of these two young children who are forever going to be traumatized is a fact that I'm not taking lightly. And to me, in this case, is an aggravating factor. I don't think Ms. Rucker and your family will ever have closure. I don't expect you to, but hopefully with today's sentencing, there will be some sense of closure. And I certainly hope and encourage, if your son Colton and if Joseph in New Jersey is undergoing counseling and therapy for this event, that they certainly continue to do so in the hopes of perhaps leading as normal a life as they can in the future, especially Joseph without his mother. And I certainly hope for all of you that the good memories, the wonderful memories that you have of Ashley can provide you at least some comfort in your grief as you go forward with your life from this point forward.
During sentencing, the judge condemned the traumatic impact the crime had on the victim's sons and the lasting grief it caused the family. Lisa survived after multiple surgeries and continues to recover.
But no sentence I impose today is ever going to bring her back or will ever, I suspect, satisfy anybody. But I will impose the sentence I think is appropriate and that is within the bounds of the law. So with that, Mr. Absher, as to counts 1 through 3, the jury having found you guilty on each of counts 1 and 2, and you having pled guilty, a plea I accepted. As to count 3, I'm now going to adjudicate you guilty of each of those 3 counts. On count 1, I will sentence you, as the law requires me to mandatory life in prison with no possibility of parole. On count 2, I'm going to sentence you to life in prison. As required, well, not as required, but I feel as appropriate in this matter. As to count 3, I will sentence you to 15 years in prison with the required 3-year minimum mandatory. You will get credit for the 1,855 days that you have already served. Count 3 will run concurrent to count 1 and 2, but count 1 and 2 will run consecutively with each other. That is count 1, then count 2, and count 3 will run concurrent to count 2, or 1, regardless. I will impose mandatory felony court costs of $518. There's a $150 attorney fee lien. Is there any restitution that I must order, or do I need to reserve jurisdiction?
I would ask you to reserve jurisdiction, Your Honor, and I think just also for record purposes for count 1, would that include also the mandatory life in the 1020 life?
1020 life, both on count 1 and on count 2.
Oh, okay, yes,
Because
so.
the jury found that the defendant actually possessed
Correct.
and discharged a firearm with great bodily harm.
Thank you, Your Honor.
So those minimum mandatories are applicable based on the jury's findings.
In November 2022, he was sentenced to 2 consecutive life terms without the possibility of parole and an additional 15 years for the firearm charge. The Rucker family also filed a civil lawsuit against Absher, the condo association, and the security company, alleging negligence that allowed him access to the property. They hope justice brings some peace as they honor Ashley's memory. In 2019, Marshall Hendricks shot and his friend Rory Neto during an argument in Idaho Falls. The confrontation began over a dispute involving Hendricks's relationship with Neto's ex-girlfriend, escalating when the two men met in person. Despite initially agreeing to a fight, Hendricks shot Neto. After fleeing the scene, Hendricks was arrested and charged with second-degree murder. Though he initially pleaded guilty to voluntary manslaughter, he later withdrew the plea and chose to stand trial, claiming he shot in self-defense, believing Neto was reaching for a weapon. In June 2022, Hendricks was convicted of second-degree murder after a jury deliberated for several hours.
Yeah, I screwed up, possessing a firearm in the first place. I had no business having it. May I address the family?
Actually, the message will be received as they are here, but I would prefer that you look directly at me and speak to me.
Words can't describe, how sorry I am for all of this. And I'd do anything to go back and change it. Anything. Words just can't express. I'm sorry. Yeah, I know them well. No, I'm sorry.
At his sentencing, Hendricks tearfully apologized to Neto's family, expressing deep regret for his actions.
Appreciate everyone involved in today's sentencing. I sentence you to the maximum of 5 years fixed with the more dominant offense of second-degree murder. The court is going to impose an 11-year fixed with a indeterminate period of 25 years. That is a 36-year sentence. It exceeds what the state had asked for. I do that primarily because of your appearing before the court today with a very significant prior criminal history and the loss of life being so consequential. I think it's necessary to have the state in your life well into your latter years of life, and if at 36 or 7 with that sentence you're close to 80. And I think that's the appropriate indeterminate period. These will run concurrently. The court will impose a $5,000 compensatory fine and a $5,000 fine. The court accepts that there will likely be restitution related to counseling if necessary, that would remain open. That figure of $2,800, is that conceded by the state or the defense, Mr. Browning?
Yes, Your Honor.
All right. Mr. Dewey pronounced or stated that exact figure. It was $2,800. I know there was some change.
28, 86.40.
86.40.
District Judge Dane Watkins sentenced him to 11 years, fixed with an additional 25 years indeterminate, totaling a 36-year prison term. The judge also imposed a $10,000 fine and ordered restitution for counseling expenses, acknowledging the significant loss of life and the lasting impact on the victim's family. On May 4th, 2014, tragedy struck in Freedom Township, Michigan, when 21-year-old Chelsea Northrup was in a head-on collision on Parker Road. Chelsea was driving southbound in her Ford Fusion when 36-year-old Garrett Roe, traveling northbound in his Ford F-150, crossed into her lane and crashed into her vehicle. Roe claimed that he lost control of his truck after reaching for his ringing cell phone. While investigators suspected that alcohol and cell phone use played a role in the crash, Roe's blood alcohol content was not specified. Northrup the scene, while Roe sustained non-life-threatening injuries. At Roe's sentencing, he expressed deep remorse, apologizing for the devastating impact of his actions. Chelsea's father, Kai Northrup, delivered a heartfelt victim impact statement in court, describing his daughter as a vibrant and loving person whose life was tragically cut short.
My name's Kai Northrup. I'm the father of Chelsea Northrup. And like Mark said, I've been sitting here and just listening to him speak. For like 6 months, I've been just waiting to get this moment, to try to figure out what I'm going to say. And every night was different. You know, I come up with something to say, something not to say, and everything's changed. There's not enough words to describe Chelsea and who she was, what she could have become. Chelsea was a beautiful, energetic, loving young lady, full of life, and lived her life to the fullest. To know Chelsea was to love her. Her personality and smile was infectious. Her laugh unforgettable. Chelsea was a precious granddaughter, a devoted girlfriend, a sister that was always there, a friend you can always count on. Proud hands. Something I can say, but I have the privilege of being a father for 21 years. My life stopped at night to make work. A phone call from her boyfriend saying there had been an accident and they were working on it. Now I'm forever haunted and scarred by the vision and words of a state trooper putting his hands on my shoulder, saying, "Sir, I'm sorry. Your daughter's deceased." There's nothing worse than losing your child. Often. But one thing that Mr. Roe will be able to do is to still be able to see his kids. I won't, ever. He'll still be able to hold his kids eventually, to kiss them, to see them. I will never, ever hold Chelsea again in my life. Just please don't forget that an innocent life was taken here. Your Honor, it's in your hands. I hope that you will make an example, set a precedent that this is not acceptable, that the consequences are held to your actions, that this has to stop. So when you do this, please, Your Honor, and set this sentence, please don't dishonor my daughter, Chelsea, or there's no longer this.
Kai spoke about the irreplaceable loss and urged the judge to set a clear precedent for accountability in cases involving reckless behavior. In response, the judge sentenced Garrett Roe to a prison term of 2 to 15 years, recognizing the severity of the crime and its profound effect on the Northrup family. Michael Madison was born on October 15, 1977 in East Cleveland, Ohio. As an adult, Madison developed a criminal history, including drug-related offenses in 2000 and 2001. In 2002, he was convicted of attempted rape and served 4 years in prison. Upon release, he was registered as a offender. Between late 2012 and mid-2013, a series of disturbing crimes began to unfold. The first known victim, 28-year-old Terise Powe, disappeared in October 2012. The second, Angela Deskins, 38, vanished in May 2013. The third and final victim, Sherelda Terry, was only 18 when she went missing in July 2013. On July 19, 2013, a foul odor coming from a garage behind Madison's apartment caught the attention of cable workers. When police were called to investigate, they discovered the decomposing body of Sherelda Terry. A broader search of the surrounding area led to two more grisly discoveries. Powe's body was found in a nearby field, and Deskins' remains were located in the basement of an abandoned house. All three women had been bound and wrapped in trash bags. That same day, police arrested Madison after a brief standoff at his mother's home. He later admitted to killing Powe and to disposing of the other bodies, though he claimed not to remember the murders themselves. On July 22, 2013, Madison was formally charged with 3 counts of aggravated murder and 3 counts of kidnapping. In court, his bail was set at $6 million, and he waived his right to a preliminary hearing.
In the first charge, you're charged with aggravated murder in violation of Ohio Revised Code 2903.01. It states that on or about the 22nd day of July, you did purposely cause the death of an unidentified female while committing another felony. The offense was committed 1 week to 9 months prior to the finding of the body. That is a Jane Doe murder. The second murder is the same date, on or about the 22nd day of July. Michael Madison did purposely cause the death of an Angela Deskins while committing another felony. The offense was committed 3 weeks or a few weeks prior to the finding of the body. And then there's a third murder charge. On or about the 22nd day of July, Michael Madison did purposely cause the death of an unidentified female while committing another felony. The offense was committed 1 week to 1 month prior to the finding of the body. All of those are felonies of the first degree because they are aggravated murder. They are punishable by a possible death or life in prison and a $100,000 fine. You understand that?
Yes.
There are also 3 additional charges of kidnapping. The complaint states that on or about the 19th day of July, Michael Madison did knowingly force, threat, or deception, use of deception, restrain Angela Deskins of her liberty with a purpose to terrorize, inflict serious physical harm, and purposely cause the death of Angela Deskins. This offense was committed weeks prior to finding the body. That is kidnapping. That's a felony of the first degree. There's also a second charge of kidnapping where it states that on the 19th day of July, Michael Madison did knowingly force, threaten, or use deception to restrain a Jane Doe of her liberty with the purpose to terrorize, inflict serious physical harm, and purposely cause the death of that Jane Doe. This offense was committed 1 week to 1 month prior to the finding of a body. And then there's a third charge of kidnapping stating that on or about the 19th day of July, Michael Madison did knowingly force, threaten, or use deception to restrain a Jane Doe of her liberty with the purpose to terrorize, inflict serious physical harm, and purposely cause the death of that Jane Doe. This offense was committed 1 week to 9 months prior to the finding of the body. Those are felonies of the first degree, punishable by up to 3, 4, 5, 6, 7, 8, 9, or 10 years in prison, and up to a $25,000 fine for each one. You understand that?
His trial began on April 4, 2016. Over the following weeks, jurors heard chilling evidence, including forensic details, witness testimonies, and Madison's own statements.
Count 1, aggravated murder, guilty of Terise Powe. Firearm specification, did not prove beyond a reasonable doubt the defendant had a firearm on or about his person. Specification, sexual motivation. The defendant did commit the offense with the sexual motivation. Course of conduct specification, guilty of purposely killing Terise Powe, Angela Deskins, and/or Sherelda Terry as charged in count 1 of the indictment. Felony murder specification, did commit the offense while committing, attempting to commit, or fleeing immediately after committing or attempting to commit kidnapping, and was either the principal offender, or if not the principal offender, committed the aggravated murder with prior calculation design as charged in count 1 of the indictment. Count 2, aggravated murder. guilty of aggravated murder, purposely causing the death of Shatisha Sheely with respect to kidnapping. Firearm specification, the state did not prove beyond reasonable doubt that there was a firearm on or about his person. Sexual motivation specification, the defendant did commit the offense with a sexual motivation. Course of conduct specification, the defendant is also guilty of purposely killing Shatisha Sheely, Angela H. Deskins, and/or Sherelda Terry, as charged in count 2 of the indictment. Felony murder, the defendant did commit the offense while committing, attempting, or committing, etc., the offense of kidnapping. Felony murder specification, answered in the affirmative. The defendant did commit the offense with respect to the kidnapping and was the principal offender, or if not the principal offender, committed the crime with prior calculation and design. Felony murder specification, the defendant did commit the offense while he was attempting to commit rape, and the offender was the principal offender in the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. Count 8, aggravated murder. Find the defendant, Michael Madison, guilty of aggravated murder, purposely causing the death of Sherelda Terry while committing or attempting to commit kidnapping. The firearm specification is answered in the negative. The state failed to prove or did not prove beyond a reasonable doubt the defendant had a firearm. Sexual motivation specification, it's answered in the affirmative. The defendant did commit the offense with the sexual motivation. Course of conduct specification, the defendant is guilty of purposely killing Sherelda Terry, Shatisha D. Sheely, and/or Angela H. Deskins. Felony murder specification, the defendant did commit the offense while attempting to commit the offense of kidnapping, and was either the principal offender, or if not the principal offender, acted with prior calculation and design. Felony murder specification, that the defendant did commit the offense while attempting to commit the offense of rape, and was either the principal offender in the commission of the aggravated murder, or if not the principal offender, committed the aggravated murder with prior calculation and design. Count 9, kidnapping, and the named victim is Sherelda Terry. In the sexual motivation specification, the defendant did commit the offense with the sexual motivation. Count 10, rape. The defendant is guilty. He engaged in sexual conduct with Sherelda Terry. Firearm specification. Find the state did not prove beyond reasonable doubt that the defendant had a firearm. Count 12, abuse of a corpse. Guilty of abuse of corpse of Shatisha Sheely. Firearm specification. The state did not prove beyond reasonable doubt the defendant had a firearm. Count 13, abuse of corpse. Guilty of abuse of corpse of Angela H. Deskins. Firearm specification. The state did not prove beyond a reasonable doubt the defendant had a firearm. Count 14, abuse of corpse. The defendant guilty of abuse of corpse, to wit, Sherelda Terry.
On May 5th, 2016, the jury found him guilty on all counts, including murder, kidnapping, rape, and abuse of a corpse. During the sentencing phase, the jury unanimously recommended the death penalty.
I am struck by the sheer inhumanity of what one human being can do to not one, but 3 human beings. It is incomprehensible. You cajoled, lured, and deceived Shatisha Sheely, Angela Deskins, and Sherelda Terry to your apartment for your depraved purposes. You went on to abuse the corpses of these 3 victims. You stripped them from the waist down. You folded them in half, binding them so that their feet were up by their ears. You wrapped them in multiple layers of trash bags, and you discarded them. Upon consideration of the relevant evidence, the testimony exhibits admitted in mitigation, it is the judgment of this court that the aggravated circumstances of course of conduct, felony murder, kidnapping, felony murder, rape, of which the defendant was convicted, outweigh the mitigating factors by proof beyond a reasonable doubt. Accordingly, the sentence of death is imposed upon the defendant, Michael Madison, on counts 1, 4, and 7.
On June 2, 2016, Judge Nancy R. McDonnell formally sentenced Madison to death. In July 2020, the Ohio Supreme Court unanimously upheld Madison's convictions and his death sentence, confirming that his trial had been fair and that the evidence against him was overwhelming. Today, Michael Madison remains on death row at the Ross Correctional Institution, awaiting execution. Anthony Sowell was born on August 19, 1959, in East Cleveland, Ohio. He later served in the United States Marine Corps from 1978 to 1985, earning several commendations, including the Good Conduct Medal and the Sea Service Deployment Ribbon. After leaving the military, Sowell returned to civilian life in Cleveland, where he struggled to adjust. In 1989, he was convicted of attempted rape after luring a pregnant woman into his home and attacking her. He served 15 years in prison and was released in 2005. Following his release, Sowell found work in a factory for a time and later survived on unemployment benefits. He moved into a house at 12,205 Imperial Avenue on Cleveland's east side. Neighbors frequently complained of a foul odor coming from the property, though many attributed it to a nearby sausage factory or the general condition of the neighborhood. During these years, Sowell quietly continued his crimes. Between 2007 and 2009, he lured women, many of whom were struggling with addiction or poverty, into his home. There, he raped and murdered them, hiding their decomposing bodies throughout his house and yard. In September 2009, a woman named Latundra Billups reported to police that she had been lured to Sowell's home, assaulted, and barely escaped. This report led authorities to obtain a search warrant. On October 29, 2009, Cleveland police entered Sowell's residence and discovered 2 decaying bodies. As they continued their search, they found more remains, eventually uncovering the bodies of 11 women. The discovery shocked the nation and raised serious questions about how so many women could go missing without thorough investigation. Sowell was arrested 2 days later, on October 31st, 2009. In total, he was indicted on 85 counts, including charges of aggravated murder, kidnapping, and abuse of a corpse. His trial began in June 2011 and lasted several weeks. Prosecutors presented graphic evidence, while defense attorneys focused on Sowell's alleged history of abuse and mental health struggles. On July 22, 2011, after more than 15 hours of deliberation, the jury found him guilty on 82 of the 85 charges.
Count 1, the charge of aggravated murder. We, the jury in this case, being duly impaneled and sworn, do find the defendant, Anthony Sowell, guilty of aggravated murder, purposely and with prior calculation and design, caused the death of Tanya Carmichael. With respect to the charge in count 7, as it relates to the aggravated murder of Nancy Cobbs, the jury, being duly impaneled and sworn, finds the defendant guilty of the aggravated murder of Nancy Cobbs. Count 14, the charges, the aggravated murder of Tashana Culver under Revised Code Section 2903.01, subsection B. In that count, all 12 jurors have found that the defendant is guilty of the charge of aggravated murder in purposely causing the death of Tashana Culver.
During the sentencing phase, Sowell's niece, Leona Davis, testified about the severe abuse she endured in the household.
Ones that endured that type of beating, as far as taking off the clothes and being tied up, were you and your siblings, correct?
Yes.
All right, but not your brother Robin, he was older, right?
Right, he didn't get it.
All right, so as far as this type of discipline, you, your sister Ramona?
Yes.
Your younger sister?
Pearl Hatcher, Darnell, and me and Ramona and Monica.
All right, so you were the only ones that got that type of discipline, correct?
Yes.
And while this was going on, what were you thinking?
Nothing. I just hated it though. We had to like walk around on pins and needles when they come in, you know, try to stay out of their way.
And so while all of this was going on, so Anthony, he wasn't somewhere hiding in a corner. Was he?
No.
All right, he was actually watching this?
Yes, he was.
And you said as far as his discipline, it could take place anywhere from morning, afternoon to 2, 3 o'clock in the morning, correct?
Yes, yes,
And you would have to go to school the next day or later on that day?
yes.
And you explained to us or described for us a time that you actually took some pills to school, correct?
Yes, I did.
All right, and did you ever take those pills?
No.
All right, and so when you were taking these pills, what were you going to do with them?
I thought they would take me out the house. That's why I took them to school.
All right, so you actually wanted to harm yourself?
No, I didn't want to harm myself. I didn't want to take the pills. I just wanted somebody to give me some attention so I can get out the house.
All right, so your intent wasn't to
Hurt
take
myself.
the pills
Right.
to hurt yourself, commit suicide, an attempt?
No.
But in hopes of getting yourself out of that house?
Yes.
All right, and as it relates to taking the pills, is it fair to say that setting those fires, that was your same reason for setting the fires, to get out the house?
Yes.
All right, and in fact, when you went to the juvenile detention center, based upon our conversation, is it fair to say that any time you were about to be released, you did something else to keep you there?
No, not at the detention center, at Sagamore Hills.
Okay, at Sagamore Hills.
Yes.
What about at the detention center?
I went to court and the judge started yelling at Gertrude, and I guess I told my story to her and I never went back. They sent me over to Messenbaum Children's Center.
All right, so when you left that house at the age of what were you?
12.
12 years old?
Yes.
When you left that house, is it fair to say that you never went back?
No.
All right, and so from the juvenile detention center, you went to the Messenbaum Center?
Yes, I did.
All right, now, did you want to go back to the house?
Never.
All right, so were you okay with going to the Messenbaum Center?
Oh, I loved it.
What did you like about it?
I mean, it was kids that had troubles like I had, but the kids got to talk to each other. It was real nice.
All right, so again, it was anything to get away from that household on Page Avenue?
That's right.
Now, growing up, did you feel that you and your siblings were treated differently versus your aunt and your uncles?
Yes.
Okay, did you ever figure out why you were treated so differently?
No, I never found out.
But clearly it was a distinction between the treatment that you received versus your aunt and uncle, correct?
Yes.
All right,
Yes.
and this was a household that was, you had lots of boutiques.
Yes.
All right, the house was always clean because you and your siblings made sure of that, correct?
Yes.
All right, as it relates to these household chores, did you ever see your uncle and your aunt, did they have their responsibilities as chores?
Anthony
chores?
did, but Terise, she was too little.
Okay,
Yes.
and when you say Anthony, what were his chores?
I'm not for sure.
Okay, but he had chores as well?
Yes, he did.
Did you ever see him being disciplined by his mom or grandmother?
No, never.
Never saw him getting a whipping?
No.
Never tied up,
No.
naked? Nothing
No.
like that? Not even a belt?
No.
Switch?
No.
Now, as relates to Sagamore Hills, and I believe you went to Sagamore Hills after you left Metzenbaum, correct?
Yes.
All right, and if you will, describe for us what type of facility is Sagamore Hills?
It's a facility for girls and boys, but girls stay in one unit, boys stay in another unit, and the units are locked down, so you can't get out. And the bedrooms and stuff is in there. They have one room in there for like if you bad, it's a seclusion room. And if you bad, you stay in that seclusion room with no mattress or cover or anything.
And do you know exactly why you were being transferred to Sagamore Hills?
No.
And so, how long did you stay at Sagamore Hills?
Until I was 17.
All right. Was there ever a time during the time that you were at Sagamore Hills that there was some talk about letting you go home?
Yes, there was.
All right.
Yes.
And what was the nature of that talk?
Well, not me going home, but me being sent to another foster home or something like that, and I didn't want to get out. So that's when I started really acting up because they was trying to get me out, but I didn't want to leave.
She recounted that Sowell began sexually assaulting her. The abuse was so severe that Davis once set a fire in the house, hoping to be removed by authorities. She stated that she never disclosed the abuse until after Sowell's arrest in 2009.
We'll now read the jury's verdicts. I'll ask the defendant to please rise. With respect to the matter of State of Ohio versus Anthony Sowell, criminal case number 530885, sentencing proceedings as to count 1, Tanya Carmichael. We, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances which the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon the defendant, Anthony Sowell. All 12 jurors have signed their name to this verdict form and have not completed the additional form with respect to life without parole as directed by the court. Moving on then to count 7, sentencing proceedings relating to Nancy Cobbs. We, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances which the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon the defendant, Anthony Sowell. All 12 jurors have signed their name to this verdict form and have not completed the alternate verdict form regarding life without parole. With respect to count 13 and Tashana Culver, we, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances which the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon the defendant, Anthony Sowell. And all 12 jurors have signed their name to this verdict form and again have not completed the contrary form. With respect to count 19 and Crystal Dozier, we, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances which the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon the defendant, Anthony Sowell. All 12 jurors have signed their name to this verdict form and did not complete the opposite form.
On August 10th, the jury recommended the death penalty. Judge Dick Ambrose agreed, formally sentencing Sowell to death on August 12, 2011. Sowell was sent to death row at the Chillicothe Correctional Institution, where he remained while his attorneys filed appeals. In 2016, the Ohio Supreme Court upheld his conviction and death sentence. In early 2021, Sowell's health deteriorated due to a terminal illness. He was transferred to Franklin Medical Center in Columbus, where he died on February 8, 2021, at the age of 61. After his death, the city demolished his home, and in 2021, a memorial called the Garden of 11 Angels was created to honor the women he killed. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.